composition that we have here and the topic that's been given, I'll try my best to keep this conversation as diverse as possible. We have constitutional experts, we have people with a significant background and experience in criminal law, and we have people from the commercial side as well. So, given the nature of the topic and its sweep, I'll try to cover as many bases as possible, but without making it sure that it doesn't meander in different directions. So let me start off with a couple of questions on the larger question of perhaps the systemic issue when we speak of moving from malady to remedy. The macro question that seems to be the talk of the town these days is whether or not the collegium system is doing us any good, and whether do we need perhaps a second shot at the NJAC. Now clearly this question has its own political overtones, but I would want to keep this discussion as constitutional as possible within the realm of policy, and therefore let's just open this up. So we'll start with Mr. Dubey.
Thank you so much, Sai. It's a very pertinent question you have put, that's a collegium system. In my opinion, there is no problem in the collegium system, because the collegium system in existence for last 30 years. And it is not like that the collegium has got the absolute power. Ultimately, the recommendation by the collegium is the subject matter of the scrutiny by the executive also and the bureaucrats. You have to go through the biodata, CV, backgrounds, integrity, knowledge, everything. You have to put your agency like the IB, and you are collecting all the information related to the person who is going to be elevated as the High Court judge and the Supreme Court judge. And there is a power with the government to make the recommendation, accept the recommendation or return the recommendation with the few reservation and the finding on the candidature of the person concerned. So we can't say that this is there is any fault and there is any loopholes in the collegium system. And you see the background when the collegium came, there was some instances where the Supreme Court passed the order in 3 occasion, and there was a continuous supersession of the senior most judges. The person who were got elevated as an additional judge, they were not getting the permanent post, and the government was interfering everywhere. So ultimately the Supreme Court says, no, the person is coming. And interestingly, the collegium, the main purpose for the collegium was there because the collegium has the opportunity to interact with the member of the bar. And they were having the information how the person is doing and what is his expertise. So I think the collegium system is the demand of the day, and there is no problem in the collegium system.
Just so that I have a sense of where this discussion is going, and just for the benefit of the rest of the panelists, perhaps the two limbs of the argument that I'm hoping for your opinions on is, one is the question of constitutionality, and the second is the question of desirability. And within the second limb of desirability, whether this system is consistent with the concept of a parliamentary democracy, coupled with whether it furthers or impedes the cause of transparency in an all-important institution. These are perhaps the areas that I would hope that you could contribute on. So, Mr. Rao.
Thank you, Sai. You see, I was one of those who wrote earliest on this idea of appointment and transfer of judges. It was, plaguing the system right from the beginning. And way back, my first article I wrote was a critique on the previous legislation that was being brought into force, that is the Judicial Accountability and Standards Bill. It was a bill, it never got passed to this thing, and it was allowed to lapse. I said, why do you punish or prosecute errant judges? Ensure that the entire system of appointment is merit-based and is transparent. So after that came the NJAC. Now the NJAC essentially meant to be a partnership, which it was originally there, between the executive and the judiciary. The appointment process. Earlier it was loaded in favor of the executive, Then now the pendulum has swung all the way. It's completely loaded in favor of the judiciary. And now the midway has to be restored because this is a balance. Now at the time when it was being done and all done by, once there was the first case was the judge's case called the judge's transfer case. There the court held a particular point of view. Then the the Supreme Court advocates on record actually petitioned the court. And then there was the second time when it was done, when the whole pendulum swung to the other side, and where a consultation, concurrence was meant to be consultation, and finally the collegium system, as it were, was already in existence when the previous appointments were being made. It's a misnomer that many people think that the collegium system has come into existence by these judgments. Whether it was 3 judges or 5 judges was the question which was dealt with. Now, having said that, now once there is a constitutional amendment for the purpose of creating a kind of mechanism, a system, a forum through which all appointments are scrutinized, is a very healthy thing for democracy. And in a democracy, all 3 limbs of the government, legislature, executive, judiciary, function by checks and balances. So unless there is this partnership where one limb of the government doesn't feel that it's being ignored, there's no transparency, they are not being taken, they are not being taken into confidence, you will find this problem continuing to persist. Therefore, I think the NJAC was a very, very healthy development for the appointment of judges. There may have been some lacuna which could have been corrected, which has not been done. In fact, this morning I was with one of the most eminent jurists of this country, Professor Upendra Bakshi, whom I had the honor of discussing. And what transpired and what came out of it was that the government can reintroduce the same legislation with a few amendments to make up for what was lacking. Thank you.
I think I tend to agree with Dr. Rao when he says that there is this need for a more consultative process. The pendulum has swung to the very extreme on the other side, where we currently have a system which has broadly served us well, but there are serious questions on transparency, on what is this mysterious ritual that leads to somebody ending up on the bench and other people who do not similarly end up. So you definitely need a more consultative process, maybe not something on the lines of something as extreme as a Senate hearing, possibly in a US Supreme Court situation where anything that can possibly be brought up is brought up before you confirm the appointment of a judge, and there is a cross-examination that goes on before somebody is elevated. Maybe not on those lines, but somewhere in the middle, I think you need to find out a process that is consultative, where you bring on board the views of various stakeholders, and at the same time, you do it in a manner which does not broadly compromise the independence of the judiciary, which again is a part of the basic structure. Now, how, it's the devil and the God, everything is in the details here. And I think a new, revamped, retweaked NJAC with possibly something more than just the Honorable Prime Minister and the leader of opposition being there taking this decision, maybe a more broad body with a wider composition to examine the issues, examine the credentials, the background, and so on. Maybe, maybe a wiser middle path to this. And I think that is where I sit on the issue.
I would agree with what Bharat has to say. I think it's more about a wider sort of panel deciding, more like, definitely not like the US system, more like the UK system where there is a wider panel that decides. I think that is the need of the hour in the sense that that would probably aid in helping getting more more judges on various benches that would also deal with issues of delays, maybe, that would also deal with issues of any apprehended bias that ends up coming up. And I think going forward, the need of the hour is definitely to have a more involved process. Also, the system that's functioned for the last 30 years, as Mr. Dubey pointed out, has served us, but with times I think we need to change. And it definitely needs to be more participative in a democracy which is as robust as India.
Thank you, Sai. I think there is a consensus that there is a wider need for having a more mutually cooperative system for appointment of judges. But that said, the question that arises is, where do you draw the line? Because a part of it has been discussed in the 3 judges' cases. Justice Kerr in the NJAC case had brought up the principle of reciprocity, where one person feels indebted. So the question that arises is, where does one draw the line? How wide is the spectrum? And what is the ultimate procedure we're looking for? What is the ultimate goal? We have to have a merit-based approach and appointments.
So, with the permission of the panelists, given that we have had some interesting inputs here, can I explore the topic a bit more? So, I completely agree with Ms. Nagpal's position that I think when the pendulum swings to the extent of the US, then it becomes more or less a political appointment. So I understand that. On the other hand, on the other side of the Atlantic, you of course have a Judicial Appointments Commission. So there's a greater participatory process there. Now, one of the things that perhaps I am trying to unpack is, I don't think it's possible to do away with the concept of a particular ideological bias. As long as you're a human being with your own independent mind, I think bias is something that is to be expected. Now, you can perhaps come out with artificial ways of suppressing that bias, or you can perhaps create a system where there is a plurality of biases, which is to say that there is more representation from more than one point of view, particularly when it comes to matters of human rights, when it comes to matters of duties, when it comes to matters of, let's say, the relationship between constitution and the society, specifically in the form of religion, so on and so forth. Now, given that at least some jurisdictions have a very clear concept of recognizing certain judges as conservative judges and certain judges as liberal judges, would it make sense for us to have a certain class of, let's say, de facto categorization, such as the liberal versus conservative, so to speak, at the very least from the appellate level, from the high court level, and then perhaps hope for a more balanced Supreme Court, wherein both points of view, and of course all other shades in between, get a fair degree of representation in the Supreme Court? Because if that's not the case, perhaps the Supreme Court's position might end up becoming the position of one particular point of view, as opposed to being a representative of a rainbow of opinions. Is that something that panelists would perhaps weigh on? And let's see where the conversation goes from there before I come to the next limb of the argument.
See, Sai, you have rightly put this question. That's the nature of the judges, like the conservative judges, liberal judges. So, in my experience, what I have found, you'll find so many kind of the judges and their backgrounds, their schooling also, their basically association with the society also, whether they are aware of the problem of the public at large or not, how much they are closer to the society's problem, and whether their knowledge is based only on the jurisprudence and without having the practical knowledge. So these all are the factors. So you will find the variation in the approach of the judges. And you must remember, you have done a matter that's a marital rape, and there was a lot of discussion about the societies. Everything was discussed and there was a disagreement in the judges. So this is the philosophy and this is the thought. There's so many things, there's the religion things, the regional things. So it's a mixture of everything. So I would say the justice changes from the person to person, chair to chair. There is no hard and fast any rule. There is no universal rule. There is the appreciation. The appreciation is the basically the appreciation is the interpretation, which varies from the person to person. So it has to be inevitable. It is inevitable. It will happen. And one thing I would also like to mention, that's a judge's appointment, the collegium system. The collegium system, we also have the drawback in the collegium system. Like in past several years, you will find the people who are getting the elevation as the high court judges, mostly they are working for the government or they are very close to the government. Even the nepotism, you can't rule out the nepotism. They are getting the more access to the judicial system, and the competent, the lawyers are not getting the opportunity. These all are the loopholes. But as Mr. Dewan has pointed, what is the yardstick? What you are looking for? How you are going to change the system? It is not the overnight things that you can change the system. You have to first change yourself. Then you can go to the system. Whether you are bringing the NJSC or you are the collegium system, ultimately the people have to work. and the people have to be fair. It is not like that in the bureaucratic thing you are not getting any biasness, only the judicial thing you are getting. Everywhere there is a biasness and there is a difference of the opinion.
Just for a moment, can I just make one point before you proceed, sir? On the question of the collegium system, since it's your position that the collegium system is itself a product or is a pushback because of interference by the executive with respect to the appointment, my only question would be, would that be a sufficient reason for the judiciary to interpret the provision itself in such a way that it gives it the power with respect to its own appointments beyond and over and above what was the original intent of the constitution? Is that something that I certainly wanted to consider? Because if institutional pushback translates to shifting of constitutional goalposts and interpretation, then clearly we are not looking at some hard, bright and red lines. You're looking at a situation that it's by and large, then it comes down to a power tussle. Beyond that, there is nothing to it. Is that the way we are supposed to be looking at it? In which case, why does one particular institution get to pontificate to the others? And why don't the others get even the right of say or stakeholdership with respect to the functioning of the one? We are not asking for the right of absolute veto. And in a democracy, can an institution which effectively functions as the watchdog of the constitution say, I will not just not listen to the people, the only chamber that I think I will listen to is the echo chamber that I create myself. Would that be a fair statement to make? In which case, how different is it from the concordat of popes that was created in the Catholic establishment prior to the Protestant Revolution? How do you think we go about it then?
You see, I belong to a generation where I have seen the previous working of the system prior to the collegium coming into existence. And in those days, governments were weak. There were, every few years the government would fall and they would change. And there could be, somewhat a disturbing feature of not having a stable kind of system of appointment of judges, and they were getting delayed, etc. Also some bit of interference, let's say. But you're right. I wouldn't say that itself gives reason for the judiciary to interpret the provisions in a manner where the entire process is, controlled by them. I'm not able to agree. I will answer this in an interesting way. I'm a student of political science as well. There's what is known as the Hegelian dialectic. Now, Hegel said, which Marx later changed, that all history moves through theses, its exactly opposite antitheses, and finally, both of them, from there results synthesis. Theses, antitheses, and synthesis. Then synthesis will become theses, and thereafter it is exactly. So therefore now it isn't, I wouldn't say that I am particularly I'm particularly disturbed about the fact that something like that happened. It was probably the need of the time, but not necessarily the correct, the correct manner in which it ought to be. Today, we are very happy independence of judiciary is recognized, basic structure is recognized, and in those days the judiciary was really, being treated as a subordinate organization and not being given due respect. There was superstition of judges, and all of that was happening. So given we have come to a very healthy situation at the moment, but not the perfect one. Now when you create a forum which is completely dedicated to assessing the pros and cons of each appointment, getting a complete idea of all those who are on the horizon, who can be on merit considered for judgeship. Now let me tell you, it is a wrong presumption to believe that if the executive and the judiciary were sitting together to decide upon a candidate, they will disagree.
I agree.
They may come to a consensus about the right candidate. Please let us not go into this belief that they are going to be at loggerheads. They may say, all right, if not this, all right, both of us agree on that third candidate, fine. That is the process, consultative process, which we are looking at. First point. Second point, what are the qualifications of a judge we are looking at? You said rainbow kind of a thing. I would say one of the most important, the few of them, there can't be too many, it's not rocket science. Highest degree of academic qualification, because you ought to write judgments, you ought to have an analytical capacity, you ought to know law, you ought to have knowledge. We don't want people from political bias. But there's a beautiful word in the entire jurisprudence of law which is called without prejudice. The man must essentially be known to have a mindset, a nature, a personality of being someone who is objective and without prejudice. He need not, the only thing that you need is his background. whether he's from intellectual property, whether he's a cyber law expert, whether he's a taxation expert, whether he's a constitutional expert. The political bias is not required at all, because that bias, whatever he may be, it can be dealt with on merit based at the point when a person is trying to adjudicate. You don't need to have any political bias as such. If he feels that certain political position is wrong, despite the fact that he supports or believes that that is right, then he will treat it as wrong and it is being wrongly applied. Let me give you an example. Suppose a particular outfit is there and they are saying, do 99% reservation. Now that outfit some fringe elements may come and say it, but he as a judge would say, look, that is not correct. That's not the way to go about it. So therefore, what we are looking at is essentially very high academic qualifications, a temperament which is of a judge. That is, that he is unbiased, without prejudice, and he has a proven track record of that. Now, who will do it? Many times, our collegium, our people in the system, I'm not blaming them, may not be having a time. You must devote your time to adjudicating matters before you. How will you sit and assess all this? There needs to be a completely expert forum to deal with it, which is analyzing all of the things that we can't do overnight, and we are saying there is backlog, so many judges have to be appointed. So given that fact, I guess that an expert body, which was originally recommended by Dinesh Goswami, who was the law minister at that time, we need to adhere to that, create that, bring together the various sections who are the representatives of the government also, and you may get the best. It's not that they're going to fight with each other every day. They are also reasonable people. If, for instance, I must give you an example. Our Vice President of India is a senior advocate of the Supreme Court, an expert in law. There are people in legislature, and they have been, who are so well versed with the law. So it's a wrong.
Mr. Somnath Chatterjee, for that matter.
Somnath Chatterjee. You have other names, so you may agree with them, you may not agree with them, but they are a part of the legislature.
Correct.
So thank you. That's all I had to say.
Please.
So very quickly, 3 points on what you said. If there is an institution that's possibly not working the way it's supposed to, does the other institution come in and fill that vacuum and appropriate that power? The answer to, in my humble opinion, would be a no. If one arm is not working, you try and strengthen that arm. You do not stop using it and let it atrophy away. So I don't think the appropriation of power or reading consultation as a concurrence was good to begin with. And we need to remind ourselves that, a non-collegium system has produced stalwarts like a Justice Krishna Iyer, a Justice Bhagwati, or a Justice Chandrachud Senior. And Justice Krishna Iyer, I think, if I've read it correctly, made it to the Supreme Court in about 5 years that he served, which is absolutely inconceivable today. And we could have a Supreme Court like that. And even the super sessions which were there, I think the way the concerned judges dealt with it and the way they've made their name in the hallmarks of judicial history, I think that itself was pushback enough or a lesson enough or a response enough, rather than taking up what possibly was not a constitutionally envisaged power that you should have.
Just to interject before you finish, what if the armed forces suddenly decides that somebody is being superseded, so let me take the decision into my hands?
So but on the second point that you earlier made on whether one organ gets to decide, although we have a broad separation of powers, but at some point in the constitutional structure and framework that we have, it would ultimately fall on the judiciary to broadly set out, in a system of judicial review on what's constitutional and what's not. So at some point there would be some decision that would be made. Of course, the executive and the government would have its own ways and means to constitutionally deal with it. The third point on having, that was a very interesting point that you made on whether one should make the latent patent by having at the High Court level maybe a set of High Court judges who can be broadly labeled or categorized as conservative and liberal, and thereafter, does that sort of a system help? Broadly, in my opinion, although it has the effect of making the system more certain in terms of the outcomes or in terms of predictions on how the court may weigh in on different issues, but at the same time, that also has a very, very significant downside on over-politicizing the system, where today we have a court which can take an independent call, unburdened by the calls and the populist demands of the day. So, again, very, very complicated, but, my 2 cents on those 3 points that you made before I hand it over to Neeha.
Thanks for that, Bharat. I would really agree with, very emphatically agree with what Mr. Rao has to say, because I do think that while the system has reached a stage where it needs an overhaul, but we also have to find a balance, keeping the, the history and the legacy in mind. But also, before we move forward, I think there has to be an assessment at a level of all three systems of the executive, the judiciary, the government, to understand what is it that we're trying to achieve. Because if we go forward without that, I don't think we're going to solve the problem. I think there has to be a consultative process at that stage, whether we have to get an NJAC act back in any other form, but to sit down and understand where are the loopholes that we want to fill, what is the objective that we want to get to, and then take things forward.
Coming to your first question, I second what Mr. Dubey had said, that classification based on liberal or a conservative judge might not be the most appropriate thing, because it actually depends. It's an issue-wise situation where every judge, every independent might have a different outlook to a certain set of facts. There can't be a straitjacket formula at the outset. And coming to the second issue, I absolutely second what Rao Sir has said, that we can't presume that just because there are differences between the executive and the judiciary at one part, that they won't reach a consensus on a name. They will reach a consensus, and you need to have an objective outlook to the entire situation. You can't sideline one strong element or the one constitutional organ which ensures the checks and balances in the entire system altogether. That said, I also think that we must, with the benefit of hindsight, we are in a position to draw a line to say who will, in case of differences, whether Supreme Court will, whether collegium will succeed the executive. And I think with this, if we decide at the outset, I think we'll have a better system, we'll have a better functioning, and we'll know that in a case of a deadlock, we know who will supersede, we know what is the right way out. And I think that is where we'll reach our consensus. Being at loggerheads all the time might not be the most appropriate thing. It leads to stagnation of cases. It affects the efficacy of the system altogether. So to avoid stagnation, I think it is better that all stakeholders are called together and there is a consensus. In case there is not, we have the benefit of hindsight and we can probably have a way out at the initial step itself.
So the next two rounds I'll come. Yes. Please.
All of us who are sitting here were asked to decide the manner in which this panel has been chosen. Is it correct? Can we all decide that the manner in which all of us have been chosen is wrong? This is what exactly happened in the court. Now that, I would like anybody who would like to answer it, or even Sai Deepak who's chairing there to answer it. Thank you.
See, I think if my own views were to be aired, where I would stand is this. A government which enjoys a brutal majority obviously needs some kind of a check. Not because it's evil in itself, because after all that's the nature of the mandate. But given the nature of power, and especially a power which has been bestowed on a particular dispensation with full majority, you cannot then say that in instances where there is a government with a brutal majority, you must have some kind of a pushback mechanism, because that's not what decides a system in the first place. You need to have a particular structure that acts regardless of the nature of the majority enjoyed by the government. Second, I certainly will not submit myself to a particular position which says that people get to decide everything, because the fact of the matter is, despite having a lower house, you have an upper house precisely because it was constituted so that there are experts on subject who can have a say with respect to the populist mandate that's been given. That's exactly why the Chamber of States was established in the first place. So in that sense, where I would stand is, let there be some kind of accommodation of will as represented by the legislature. Let there be some kind of representation of the opposition as well, because they are still on the bench, no matter what, just on the opposite side. And then, of course, a certain degree of power with the Chief Justice, so to speak. My only question is that, having done so, there is absolutely no representation from the academic fraternity or the jurist fraternity. That is something that we may want to seriously consider, because these are people which we can hope have relatively lesser stakes in the wielding of power and are more interested in the evolution of jurisprudence and where we stand as far as the global pool of human thought is concerned when it comes to legal contributions. So maybe that's something that we may want to seriously consider. Now for the next 2 rounds, I'd want to start with Mr. Shashank. So the third question that I perhaps want the panelists to shed light on is, hasn't the Supreme Court become an oft used and approached court? And is it not time for us to create perhaps a layer between the High Court and the Supreme Court,
Absolutely.
where you actually have, let's say, a filtration mechanism so that absolutely essential constitutional matters really go to the Supreme Court and we have quality judgments coming out? That I think perhaps you may want to shed light on.
Thank you, Sai. I absolutely agree with you. I think there is a need for Court of Appeals now. Supreme Court has to decide the law, and they cannot be deciding bail applications. It's precious judicial time. You can't
Transfer petitions on a daily basis.
on a daily basis. That cannot be done. You decide the law, enforcement has to be done at the lower level. Supreme Court cannot be deciding merits. It can't become a fact-finding court at any stage of time. Unfortunately, there's been an influx of cases where I feel the Supreme Court is now more occupied with transfer petitions, as you said, or bail applications, and they're ignoring questions which pertain, which have large implications, issues which are pending in lower courts, which cannot be decided till the time Supreme Court finally adjudicates this. So I think there is a big vacuum in that, and I seriously support Court of Appeals. I think it's the need of the hour at this point of time.
I have a slightly different view on that. I firmly believe that, and I'd quote Justice Chandrachud here when he said the other day that the lower judiciary needs to start being taken more seriously and needs to start hearing and deciding bail applications, and there cannot be this fear or this reluctance to grant bail. So just taking a cue from that I think the lower judiciary needs to be given the due credit that they deserve, be it the lower judiciary or at the district court levels or the session courts, or even for that matter the high courts and the tribunals, because the minute that starts happening, the load on the Supreme Court starts lowering. Instead of adding one more layer, I feel, which is of course going to entail a whole systematic shift and coupled with a lot more expenditure, that can be used actually towards building the current infrastructure that we have in our existing courts to increase the disposal rates.
So you're saying the Supreme Court must be more reticent in entertaining all of this?
The SLP days should be literally considered, sacrosanct. It cannot go over a Monday, Friday, and the rate of admission has to be, curtailed.
Understood. Fair enough, please.
So very quickly, since I can see you there. I started my career at 23 as a young baby magistrate. And when I was looking at CRPC and CPC, I would think and speak to myself and say, what is it that one cannot do as a civil judge or as a magistrate? This is about empowering the trial judiciary so that again the higher courts can trouble themselves with the constitutional issues. So you look at the mandatory injunction under SRA, very similar to a mandamus. You have habeas corpus in the CRPC. When you talk about powers of supervising or monitoring an investigation, you're doing a jurisdiction akin to a criminal writ in that sense. So I think, yes, completely agree, strengthening the trial court judiciary so that they can check power, they can exercise their powers more freely. They should be taught to be less conservative, for instance, in matters of bail, for instance, for the fear of any questions being asked on their integrity and so on. I think all of that should take a back seat, and then the Supreme Court should confine itself to constitutional questions. On the lighter side, this conversation was happening. Somebody said Article 136 of the Constitution is pari materia to 125 of the CRPC. I said, why? Because 125 CRPC provides for maintenance of the wives and children of ordinary people, and 136 of the Constitution provides for maintenance of children and wives of lawyers. Because, you have another route of appeal, another go at the facts. So again, that has to stop. It's an absolute no-brainer.
I think that the screening process should be a lot more enhanced through the assistance of the registry and others, so that frivolous litigation, there is a whole lot of frivolous litigation, matters without merit, etc., get weeded out, and then serious matters come before the court, and that we need to impose costs. We need to impose costs and ensure that for everything that we are not before the court, and for every matter that comes to, the Supreme Court is something that has some merit. There is some way by which we can actually ensure that all that matters that are before the court may not require the amount of time that is being devoted to them first, and ensure that frivolous and meritless cases are dealt with more effectively. That's a better way, instead of creating a tier with so many more judges, and there, you know, it's a huge, again, like a bureaucracy.
A new ecosystem.
New
altogether.
ecosystem.
Right.
Yeah, thank you.
I do agree with Dr. Rao. There is no purpose of creating so many forums. You know, recently the Chief Justice of India and the other judges are saying that we should strengthen the hands and the power of the lower judiciary. Why this situation came? Merely creating the forum is not the solution. Why this situation came? Because you have the hierarchy. You are not letting your judicial officer, lower judicial officer, to work with the free hand. When I joined the profession, there was a very famous case of Vishnu Pandit. The learned session judge granted the anticipatory bail. That was, person was entitled for anticipatory bail, and he got superseded. And from those days, and the Bharat is already part of the judicial system, he was there, and Bharat will correct me. After Vishnu Pandit, the Delhi judicial system, the judges stopped granting the bail. So you have basically enhanced the number of the cases, and you are inviting the litigants to approach you, because you are saying that you are the High Court, you are the Supreme Court, and you are more interested in deciding each and everything. Even you see, there was a matter in the midnight, the Supreme Court granted the remand. Supreme Court is not sitting to grant the remand. So it is the Supreme Court, is the High Court, they are encouraging this kind of the litigation. And they are not letting their judicial officer, because they have the sword on their neck. Their performance would be seen, their promotion would be stopped, they would be transferred from one place to another places. You are passing the order, but you are not strengthening your system. So there is no purpose creating. Suppose there is a court of appeal. Again, there would be the chances to go to the Supreme Court. Then the Supreme Court says, we are the Supreme, we are not going to let you do all the things. Then the High Court judges will say, no, we are the High Court. So the mere creating the forum is not going to suffice anything unless and until you create the confidence, you protect your judicial officer. Then the the entire litigation start with the lower judiciary. And most of the cases, we have three types of the cases. First cases, most of the cases, 138 cases. The second cases, that's the bail matters. You are not encouraging your magistrate to grant the bail. The magistrate is rejecting. What is the approach of the magistrate? Oh, the day of the remand, you are moving the application. No bail. Then the bail court get dismissed. You are going to the session court, no bail. Then you are coming to the High Court. Then again there is no bail. Then the people are going to the Supreme Court. How long the people will be incarcerated, and how long you are going to deprive the people from their personal liberty? And see the approach of Justice Sanjay Kishan called recently. He has called for the data. The people are inside for 18 years, 20 years, 30 years, and their appeal are not being heard. So there are so many factors. So there is no purpose of creating the court of appeal. You have to strengthen your system, and without strengthening the system, you can't achieve anything.
Thank you very much. I leave it to you now. Thank you so much.